Hi, everyone. Welcome to another Darrow webinar. We'll just wait a couple more minutes to let people join. While we are waiting, let me give a quick introduction. For those of you who don't already know, us here, we're Darrow. We're a legal intelligence company that believes in frictionless justice, which means we use AI and other technology to help plaintiff attorneys detect, act upon, and litigate impactful cases in a number of practice areas. I'm joined here by Sarah Green. We'll both introduce ourselves. I'm Joe Hughes. I'm a legal consultant here at Darrow, so I work closely with our partners, on these cases, primarily privacy cases. And I'm an attorney here in New York. Sarah?
Hi, I'm Sarah. I'm a legal intelligence analyst, which means that I use tech tools to detect and analyze legal violations online, and I focus on privacy violations. Are we ready to go, Joe?
Yeah, I think that's us.
All right. Let's dive in. So we have a few interesting and exciting topics to go over today. So just dive right into it. The first prediction that we're anticipating in the wiretap space is more diversity in the kinds of defendants and data that we're seeing. Do you want to elaborate, Joe?
Yeah, definitely. And I guess I'll say a disclaimer up top. This is a webinar about wiretap trends we're seeing in the litigation space, primarily class action litigation. And we'll also be focusing on, online website tracking type litigation. We're definitely aware, of other kinds of wiretapping class actions that are out there, but this is kind of, the area where we've seen a lot of activity. So as you said, our first prediction is kind of diversity in kind of defendants and data that we see being subject to these lawsuits. So right up top, the medical space has been a real focus of these lawsuits over the past few years. We don't expect that to change. So, our first prediction is pretty easy one that we'll see more and more of these wiretap cases against medical providers. Sarah, you agree with that?
And also even we're talking about diversity, but even within medical, so we're seeing more diversity, right? So we're seeing different types of, I don't know if we call them all medical providers, but in the medical or paramedical field. So we're seeing not just classic hospitals, but we're seeing dental, we're seeing plastic surgery, different aesthetics and esthetician clinics. So even within that, we're seeing already within that small space, we're seeing more diversity.
Right. And that'll just continue, right? Because, the classic set of facts is you have these third party trackers on a medical website, communications gets intercepted, and that's a violation of state or federal laws. And what I think we expect to see, though, is that there's going to be growth beyond that. Right. So the first area that I sort of expect to see is more financial data cases. We've seen a lot of these already happen, but not as much, right? It's not become as common. One of the things that's driving that is the utilization of the Federal Wiretap Act and its crime tort exception, which essentially means, that you can sue entities that have these interceptions, and where usually there'd be a one-party consent. If there's a kind of parallel violation of the law, that abrogates the one-party consent, right? So banks, mortgage providers, payday service loan vendors are subject to Graham-Leach-Bliley Act for financial data, and we expect to see more and more of that.
Right, and then even also more different types of laws, right? So not just the financial law, but other types of data.
Right. So it's not only crime tort doesn't literally always mean crime tort, right? It can just mean invasion of privacy. We've seen that happen too. And so financial data, I think that's definitely one we're going to see. Another area that's kind of starting to pick up is against educational providers. Think universities is a big potential target because those, they have student portals, they have donor portals, applicants. We're putting a lot of information, and because they haven't been as much of a focus, these trackers are on those websites. I think that's what we're seeing, and obviously there are things like FERPA, right, and other laws that apply to educational providers.
Right. Joe, do you think that when we're talking about diversifying data, but we're also diversifying defendants? So maybe we'll have different legal challenges. So do you see that affecting what we're going to see in litigation, what challenges we're going to see?
Yeah, definitely. And I think, in privacy cases, a big thing you're always kind of wondering about or gets litigated a lot is the harm, right? And that comes up as either Article 3
Yeah.
standing. It can also come up as whether there's, a reasonable expectation of privacy for invasion of privacy purposes. And I think with the medical space, it's been pretty easy for courts to understand that. But as we
Yeah.
expand beyond that, there's a question about the sensitivity of that data.
Right.
But we see, firms being very, plaintiffs being successful, kind of raising that there are statutory protections for this data. There's a context where people don't expect to have their data shared with advertising providers or third-party trackers. Was there anything else you were kind of thinking of on that score?
Yeah, so I think we've touched on like different types of data protected by different statutes, but I think it's super interesting and kind of what you already referenced with reasonable expectation of privacy. So we're also seeing a trend of cases against e-commerce websites or like classic non-sensitive websites where they have a cookie banner and then they allow their users the option to reject cookies or to not be tracked, to opt out of the tracking. And those cookie banners, for whatever multitude of reasons, aren't working. So we have users who are, saying, I don't want to be tracked, and they're still being tracked. So sort of what you were touching on and creating this different type of reasonable expectation of privacy. So I think that's super interesting also on the tech side.
Yeah. So just to take a step back. So when we have, I'm thinking of kind of just big shopping websites, which typically happen, courts have been pretty reluctant to find wiretapping claims or privacy harms. You're saying that in cases where the cookie banners just don't work, those are...
And then the class. So we've seen a few decisions, and we're seeing lots of cases being filed. So it's interesting. It's like we can really see the trend being created, and yeah, like it's definitely growing.
On the technical side, what's kind of happening there?
Yeah. So like I said, the user is being presented with this banner or in some form, and they're asked what they want to do. Do they want to be tracked or not? And then their input of not being tracked is somehow not being translated. So it could be we'll have different types of trackers that don't always work so well with these cookie banners. What's interesting also to see is we're going to be seeing different type of trackers, right? Because we're moving, like you said, different types of websites where users have different actions on them. Then we use different tools. We use different ad tech tools. So we could be seeing new types of trackers, more RTB trackers, real-time bidding trackers, as opposed to classic analytics and other types of trackers we're used to seeing on hospitals' websites. And also, I think what's really cool what we're doing here at Darrow is we're also trying to automate then and scale up the detection of those cookie banners that aren't working. So instead of manually checking, I'm going to reject, let's see what happens, we were able to scale up and build something a little bit bigger to detect those types of violations.
That's great. And I think that actually feeds right into our second prediction, which is essentially that we're going to see even more activity against the data brokers and the ad tech companies themselves. Just to kind of set that up briefly, typically the model is people go after the websites that have these trackers, and there have been some mega cases against vendors, but there's a whole universe of ad tech companies that are collecting and wiretapping.
So many.
Things you've never heard of, which can make them a very compelling case. And I think what's been interesting is there's been a series of decisions that have come out very recently that have even where some of the information collected, maybe per se, was not sensitive, the courts are getting this kind of growing awareness that there's this profiling and sort of what we call like cross-context tracking between these data brokers. And that feeds this massive sort of infrastructure that
Right.
uses surveillance. And
Yeah.
yeah, I don't know how that looks on the tech side from where you're sitting.
Yeah. Yeah, I think as a tech person, these cases are particularly exciting because really what I'm seeing in the complaints and also in those orders that you mentioned. So we're seeing like we're diving deeper into the tech. We're trying to understand in this legal space like what is actually happening when we say, oh, this tracker is installed on this website. Where is that data going? What's happening with that data? What's the funnel, the trickle down, and what are the actual implications of, oh, I went on my website and I click this, what's happening and who's getting that data? What are they doing with it? I think it's also a challenge, right? Because we're expecting judges to, like you said, most of us, we're not tech people. So when we have this whole detailed complaint about how the tracker uses and the code. And so yeah, I think it's really interesting because we're going into not just what's being collected, but how it's being collected, why it's being collected.
Yeah, and
Yeah.
I think something on the legal side for me is a lot of these
Mm-hmm.
early cases came up under a pen register
Yeah.
theory was kind of the leading theory. We've seen that theory come under a lot of challenge, especially when it comes
Yeah.
to IP addresses and, whether
Mm-hmm.
those are sensitive and how much this is just normal commercial activity. But I think as
Yeah.
these complaints get more sophisticated, as the, kind of activity becomes more public from one way or another, it's clear that there's just a baseline invasion of privacy.
Yeah.
And I don't know if we expect anything on the mobile side or, to these cases to kind of grow in that way.
Yeah. It's definitely, a whole, a wild, even a wilder Wild West, right? I think if it happens on websites as a Wild West, then in mobile is even more. And that's definitely something that we at Darrow are going to put a lot of effort on this year in 2026 and something we want to learn more about and dive deeper into that. All right, let's move on to our third prediction. We are anticipating more litigation and more action regarding child and teen data. Do you want to elaborate, Joe?
Yeah, definitely. I mean, this is kind of a prediction that we've been seeing, across the kind of sources that we monitor. Everyone is
Mm-hmm.
expecting, the FTC has made a lot of strong statements
Yeah.
about children and teen data being a target. We've also seen some big settlements come through very recently. And, just to be clear, a lot of this arises out of the Children's Online Privacy Protection Rule, COPPA,
Mm-hmm.
which does not have a private right of action. As it's more understood how these advertising platforms and vendors
Mm-hmm.
are both targeting children and creating spaces where children and teens are it's labeled for children and teens. Children
Yeah.
and teens are expected to be there sharing their data, and yet the data privacy practices and the tracking aren't fully disclosed. It opens up a whole range of, state law claims that can be kind of supported by the parallel cop
Right.
litigation and, sound in a very similar set of facts. And
Yeah.
what we also, expect is as the government and state regulators get more aggressive
Mm-hmm.
here, it will just unearth more and more violations that will, result in private litigation. So this is
Right. So how do you view the relationship between the regulatory and the government enforcement action versus the class action law like space? So like, do you think judges it'll be more compelling for them to get involved, or they're going to be like, oh, let's see what the FTC does. Let's see.
Yeah, I think as the government takes the position that sort of disclaiming that you collect children or teen data or professing that you
Hmm.
don't, if you're the defendant, you're these companies, while not taking
Yeah.
proactive steps to mitigate that or protect against it, we'll see a growing series of orders, settlements, or
Hmm.
guidance from these regulatory bodies saying that's, not good enough. The companies kind of haven't met
Hmm.
their standard of care, which will inform how, private litigation can attack the same issues. So
Yeah.
I can only see these two things moving together. I think the trick will be what what can be found or understood prior to government, litigation, and
Yeah.
how
To anticipate it. Yeah.
how you
Before.
anticipate what those are. And also, hopefully, as with all these things, like some of these cases never come to pass because this activity stops, right?
Yeah.
So that I do see there's going to be an especially this is not a hard narrative for courts to understand. And the
Yeah.
violations, everything just amplifies once it's children and
Yeah.
data.
Yeah. All right. Let's move on to our fourth prediction. So we are anticipating artificial intelligence to get involved in wiretapping, right? So how do we exactly see that happening?
Yeah. So I think
what do you think?
This is kind of the most out there of the predictions because we've really only seen very minimal activity so far
Right.
in the artificial intelligence or broader LLM chatbot space.
Yes.
Obviously, there were a lot of cases about chatbots embedded on websites, right? Or there have been cases about customer service over phone calls, wiretaps.
Right.
But as you look at the broader integration of AI tools into basically everything, right? That's what's
right.
and there was an interesting case that was filed against Google, basically that the integration of their Gemini tool was sort of wiretapping and reading emails. And I think you're probably
which is wild.
which is wild, right? And that's still unresolved. It's just alleged. No one's knows what's going to happen. Right. But the dynamic that sort of lawsuit points out that people want to integrate their AI tools for business purposes, but those AI tools both need data to operate, and the ultimate, what happens to that data? Is it used to train for models? Are the disclosures adequate? Is there really consent? Can you even consent to some of these things the black box AI is doing? Raises a lot of interesting questions. I don't think we have answers right now. Maybe 2026 won't be the year that this really breaks out, but I do think that a lot of people are starting to recognize that the broader existence of these massive AI models integrated throughout these tools raises the wiretap and privacy risks significantly.
Yeah, I think it's interesting in a few different ways. First of all, I think one thing you said is about, people or developers want to implement these different tools or these different LLMs, and you said something like some people, they might not necessarily know how it's collecting data, what it's doing with the data. So I think it's super interesting because I would say that's also true for any ad tech tool. I think there's a lot of these tools where we implement them, or we let's say as the website developers, they're implemented, but do you really understand how it's collecting data, what it's doing with the data? And I think it's multiplied by, I don't know, a factor of 10, right? When you're talking about AI and this model, and obviously not just in the privacy space, but in lots of other legal spaces. But what's interesting, I think, also to point out is we don't know where the AI is going to go and what new tools or 2026 is going to bring. But which is interesting, just something that we at Darrow started. We looked into a few different platforms, investigated a few cases. We've created a few cases. But what was super interesting about them is that the violation was pretty similar. We're seeing, similar trackers being implemented on different LLM or AI platforms. And so I think it's interesting that it's more of the same in some way. Obviously, it'll bring innovative and new different types of violations. But I think also interesting is, again, talking about, we spoke before about cookie reject and users, subjective expectation of privacy, right? They decide they didn't want to be tracked. And I think speaking on that subjective expectation of privacy, or how we would assume users behave, I think with LLMs and chatbots, the case is even more compelling, right? So when you're going on a website and you're, searching for things, you're not necessarily as user of oh, I'm having a conversation. But when people use chatbots or LLMs, it's much more conversational nature. And I think when and if we find those violations, those it could be a treasure trove of sensitive data, right?
Yeah, I mean, and then to kind of just, I mean, what you're talking about is something that's kind of plagued wiretap, jurisprudence is what does it mean for the
Yeah,
contents or the communication or, the
right.
contents of a communication. Some of those can
Yeah,
be pretty close calls, but yeah, if you're actually interacting with these chatbots and you're,
yeah.
literally talking to it, that should be one of the easiest elements to
Right.
make. And if I could kind of just maybe like draw a line under this, why I think this is a space to watch. And I don't know if you
Hmm.
agree with this statement, but it does seem like there's a fundamental tension between AI platforms needing data
Hmm.
to train their models and keeping
Yeah,
customer data private. And,
for sure.
that is probably what drives some of this prediction. I think the other predictions we made today, we have good authority to point to. Like we've seen things happen.
Yeah.
Probably the like farthest out there, but it almost
It's the most crystal ball of them all,
it's the
right?
most crystal ball, but it feels somewhat inevitable, just
Yeah.
because of the way and some things we've already seen.
Yeah.
So I just want to make sure we had time for questions because I
Hmm.
know we had a few. Um, so I guess a kind of a global question for you, Sarah, is, wiretap
Sure.
litigation is not new. It's been
Hmm.
really taken off in the last couple years, last few years. We've seen big settlements
Yeah.
and, a real settlement market develop. What are we seeing on the technical side from the defendants to prevent these
Yeah.
losses? If
Yeah. Yeah. So we're seeing a bunch of different things. We're definitely seeing a lot more cookie banners. Maybe sometimes as users, those are kind of annoying to us, but to us as in the privacy litigation sphere, so it's fascinating to see different types of cookie banners. Is the consent actual consent, to be litigated? But we are also seeing websites like I would say like cleaning up their websites a little bit. They're trying to use different types of tech of trackers that, on its face, or at least they claim to be more privacy compliant. I'm going to throw some tech terms out there, and I can elaborate, but I could just throw them out. So we're seeing more server-side tracking as opposed to client-side tracking. We're seeing trackers making use of more use of first-party cookies versus third-party cookies, which also kind of ties into something Google has been saying for years, and they kind of went back on it. Of Google was saying, "Oh, we're going to eliminate third-party trackers." They kind of walked that back, but we definitely saw the market react to that. We are also seeing some websites just like taking the trackers off of sensitive pages, or more sensitive pages. So on like questionnaires and things like that, maybe we'll see less trackers. But it's definitely not enough. I think, like I said before, also, when website developers implement the trackers in the first place, they don't necessarily follow through and like figure out how the data is being collected. So also when these cookie banners are being implemented, like we've spoken a few times about it in this webinar, but these cookie banners are being implemented, and they might not be compliant on the legal side. They might not, be up to standard of what's actual like consent, and then they could also just not work for whatever reason, which in my opinion also might create a more egregious or more significant violation, right, when the user actually doesn't want to be tracked.
yeah,
So a lot happening also on the defendant's side. Yeah.
yeah.
um yeah, next question, or are you seeing the questions, or am I?
Yeah, I have a question. I think I can actually probably take this one. So it's,
Okay.
what are some of the legal hurdles we see to bringing these types of cases to court? I think we've already touched on a lot of them.
Hmm.
I think that where you get away from medical cases, there's has to be more work on, identifying the harm, explaining to courts
Yeah,
how this stuff works.
it's less established.
It's less established and how this stuff
Yeah.
works and the level of profiling and tracking.
Hmm.
And we also, we do see a lot of debate about what, actual consent means in this space.
Yeah.
And I think that's just going to continue. There's a growing sort of academic literature that privacy,
Hmm.
where the United States are very much
Right.
individual. You get to control your data. That's sort of the baseline. But in these
Yeah.
contexts, that's a bit of a mirage. And some
Yeah.
courts of, when you're hit with 100-page terms of use and it's kind of indecipherable, what is
Yeah.
that consent worth and how does it apply also when your data is being, sent through many hands? I also
Right.
think, this is probably most notable on like the pen register side. And in
Hmm.
California, there was obviously legislation that's come along. We're seeing pushback from defendants
Right.
and basically end these two-party consent statutes
Right.
and block their
Right.
applicability. And we're just going to see more of that. But at the same time, it's a very volatile space. And a
Yeah.
lot of this jurisprudence exists in motion to dismiss decisions, which are just
Right.
not probably what you want for like a stable body of law. But that's probably more privacy writ general than just wiretap.
Yeah.
So I think one question actually would be for you is, how do we keep track of these trends, right? Like, okay, I mean, websites are changing every day. New data brokers come out, new
Right.
tools.
Yeah.
How do people who track this stuff and want to be in this space even keep?
Yeah. Right. Well, first of all, they can join Darrow's webinars. But yeah, I mean, it's a massive challenge, isn't it? Like, I think in general, as lawyers, like we're always in any space, you want to keep up the trends, you want to see what the new case law is. Um, Here at Darrow, we definitely focused a lot on like scaling and monitoring, right? Like I think all the trends we talked about are just like they're all enlarging trends, right? It's not like we're creating new spaces. We're just growing the wiretap space. So we definitely want to use more tech tools to make sure we're not missing things. So we're also monitoring case law at scale, especially like you mentioned with the ECPA crime tort, which is a federal statute. So we're seeing, as opposed to a few years ago, we really focused on two-party states. So we focused on like California a lot. Now we're seeing case law all over. So we kind of want to make sure we don't miss those things. And secondly, also on the tech side, in terms of detecting violations, so we've definitely put a lot of effort and time into developing tools to scale up our detection of legal violations, right? As opposed to sort of, looking at specific hospitals or specific websites. And we definitely want to get a broader understanding of what's happening on websites across domains and across different spaces. So yeah, I would say like the keyword that I've said probably like 5 times or 10 times is scaling. But yeah, we've definitely put a lot of effort into that. And I'm excited also to like use all these new tools that we have and looking forward to 2026. I feel like we're really set up. We have a toolbox. But definitely like key is like monitoring and scaling, right? Like it's just the trends are just going to keep growing.
Yeah. No.
So yeah,
Yeah. I mean, that's what we're seeing, right? And I think that's the core of these predictions is this isn't slowing
is
down
more.
because defendants,
Yeah.
new ways to violate privacy, new kind of
Yeah.
trackers, new kind of companies, and
Yeah.
new contexts and type of data.
Yeah.
So it's, I think that would be the core message, right? Like it has to be tracked. It's going to keep going, and we'll see how the courts and defendants and plaintiffs,
Yeah.
respond to those trends.
Yeah.
But I think that's kind of what we had for today. So to everyone who joined, thank you so much for listening. We hope you found it interesting. If you are interested in working on us in cases or want to hear more about Wiretap and what we do, you can always be in touch with us. I think we have an email address here, contact@darrow.ai, or reach to one of us directly. I'm Joe.Hughes at darrow.ai. Sarah?
Sarah.greed@darrow.ai.
We're easy to get. And thank you so much. And hope you all have a great day.
All right. Thanks so much. Have a great day.